Good day, everyone. Are you an alternative dispute resolution practitioner conducting mediation, arbitration, or any other form of ADR mechanism? Do you have what it takes to be OADR accredited and offer services to government agencies and have partnership with them thereafter? Let's get to know the fundamentals and requirements for the OADR accreditation, and you can be one of us. Now, it's time for us to dive in and get to know the OADR accreditation. Here is a summary of the 6 key points that we have to keep in mind. First, the OADR accreditation is mandatory only for ADR providers offering ADR services to the government, or have partnership with said agencies. Government agencies shall only partner with, or engage the services of OADR accredited ADR practitioners. Once accredited, they may provide ADR services to government agencies, such as, but not limited to, serving as an ADR practitioner, providing ADR training, conducting program and system design, and managing, overseeing or administering ADR programs. Second, the OADR confers accreditation to individual ADR practitioners, private APOs, and public ADR program who have successfully complied with the requirements under DOJ Department Circular 49, Series of 2012. Third, an OADR certificate of accreditation is valid for a period of 2 years from the date of issuance or unless sooner revoked. It is renewable and shall only cover the field of practice, or the ADR mechanism indicated therein. Fourth, any certification or accreditation granted to an individual ADR practitioner by an OADR accredited private or public APO with an ADR program shall be recognized by the OADR for the period within which said APO remains accredited. Fifth, accredited APOs that intend to offer ADR trainings to government agencies are required to obtain approval from the OADR at least 1 month prior to the intended training date. And lastly, the updated official roster of accredited neutrals and APOs are posted online via the official OADR Facebook page and the OADR webpage and the DOJ website. At this juncture, we are proud to present to you the updated roster of accredited practitioners per category. For the first category, we have the private ADR provider organizations, or the APOs. Presenting the Conflict Resolution Group Foundation Incorporated, the National Center for Mediation, the Philippine International Center for Conflict Resolution, Philippine Dispute Resolution Center Incorporated, the Philippine Institute of Arbitrators Incorporated,
the Mediators Network for Sustainable Peace, Incorporated,
the Philippine Arbitration Center in the Visayas, and the Calao, Prasad and Hofelenialo.
For the second category, we have the ADR practitioners and neutrals. Presenting the OADR accredited individual ADR practitioners and neutrals. For the third and last category, we have the Public ADR Program. Presenting the Intellectual Property Office of the Philippines. In summary, here are the figures on OADR accreditation as of this date. Any interested applicant may submit the following requirements for OADR accreditation. For ADR provider organization, for individual ADR practitioner or ADR neutral, and for public ADR program. For any questions and concerns, you may visit the OADR Facebook page or email us at acd.oadr.doj@gmail.com. Thank you.
Good morning. Before we formally start the program, please take note of the following important reminders. Foremost, please be informed that this convention is recorded. By joining, you are giving consent to the Office for Alternative Dispute Resolution, or the OADR, to record and maintain a copy of these proceedings and any information that will be exchanged throughout this event. Please observe proper decorum, refrain from using offensive language, and keep your comments relevant to the discussions in the event. Meanwhile, the post-event survey shall be posted on the OADR Facebook page following the third day of the convention. Please note that only those who registered, attended, and accomplished the post-event survey will receive an e-certificate. Should you have any reservation or related concern, kindly contact the NADRC Secretariat at National ADR Convention at gmail.com. Please stand by. The program will start shortly. We now commence the program with the invocation to be followed by the singing of the Philippine National Anthem.
Good day, everyone.
Let us put ourselves in the holy presence of our Lord. In the name of the Father, and of the Son, and of the Holy Spirit. Amen. Heavenly Father, we thank you for making all things possible. We are grateful for all the blessings that you are pouring upon each one of us amidst the challenges we are facing. Thank you for blessing us with the opportunity to gather virtually and learn together in this activity. May your wisdom and guidance be upon us all as we learn and upgrade our competencies to be of better service to the people and our communities. We humbly commit and offer every part of this activity to you as we bring you glory, honor, and praises. All these we pray in the name of Jesus our Lord. Amen. In the name of the Father, and of the Son, and of the Holy Spirit. Amen.
A pleasant morning to our distinguished guests and dear participants. Ladies and gentlemen, welcome to the Second National Alternative Dispute Resolution Convention, or the NADRC 2021, organized by the Office for Alternative Dispute Resolution, an attached agency of the Philippine Department of Justice. We are very excited and elated to see with us today thousands of participants who are joining us through Facebook Live and YouTube from all over the country and even abroad, both in public and private sectors, especially in the ADR community. Please stay tuned to our official channels, Office for Alternative Dispute Resolution, because we at the OADR have a lot in store for everyone in this year's National ADR Convention. In the next 3 days, we will be providing timely information, updates, and discussions on alternative dispute resolution in the digital era as we strive towards enabling a more efficient, accessible, and effective administration of justice in the Philippines through today's technology amid the challenges brought by the pandemic. Again, we would like to remind everyone that this convention is recorded. By joining, you are giving consent to the Office for Alternative Dispute Resolution, or the OADR, to record and maintain a copy of these proceedings and any information that will be exchanged throughout this event. Please observe proper decorum, refrain from using offensive language, and keep your comments relevant to the discussions in the event. Meanwhile, the post-event survey shall be posted on the OADR Facebook page following the third day of the convention. Please note that only those who registered, attended, and accomplished the post-event survey will receive an e-certificate. Should you have any reservation or related concern, kindly contact the NADRC Secretariat at National ADR Convention at gmail.com. Once again, good morning, everyone. You are all with us today in the second National ADR Convention. Before we start the program, we would like to greet our participants streaming through our Facebook Live and YouTube. From Mr. Emil Resuelio. Good morning, everyone, from Pesco, Caloocan City. From Miss Yasmin Incisco. Good morning, OADR, from Legal Service, NCMH. From Karen Ann Bueno. Good morning from the Dole Central Office. From Rose May Acodili. Good morning from Ombudsman Mindanao. From Mr. Jello, Angelo Alog from Coronadal City Police Station, South Cotabato Police Provincial Office, PRO 12. From Francis Nifras, good morning, Pau Bacolod City, District Office 1. From J. Tayaw, BHROD, DepEd Central Office. Good day. Gracing this convention also is a renowned practitioner from the international ADR community. Ladies and gentlemen, for the keynote message, let me introduce Ms. Chian Bao, Vice President of the International Court of Arbitration, International Chamber of Commerce. Chian Bao is an independent arbitrator and a member of arbitration chambers in Hong Kong and London. As a New York qualified Mandarin-speaking attorney, Ms. Bao has worked in international arbitration with years of practice as counsel or arbitrator for corporate entities and state-owned enterprises in a range of disputes concerning technology, joint venture, real estate, construction, and general contractual disputes. Ms. Bao served as a Secretary General in the Hong Kong International Arbitration Center, or the HKIAC, from 2010 to 2016. Overseeing key initiatives such as the revision of the HKIAC administered arbitration rules, the establishment of the Tribunal Secretary Accreditation Program, and the opening of the HKIAC Seoul and Shanghai offices. Ms. Bao regularly speaks and writes on the topic of international arbitration and is a co-author to a guide to the HKIAC rules published by the Oxford University Press. Ms. Bao currently serves as Vice President of the International Chamber of Commerce, Court of Arbitration, and is a member of the ICC Belt and Road Commission. Ladies and gentlemen, let us all welcome Ms. Chian Bao for the keynote message.
Good morning, everyone. Can you see me? Okay, turn on my camera. Okay. I see that it's on. Ah, here we go. I'm hoping everyone can see me now. It is so nice to have the opportunity to join all of you virtually, and many congratulations on dedicating this convention to the topic of justice in the digital era. It is hard to ignore the fact that there is something fleeting about this moment whereby without action, it will be lost forevermore. And the title of this conference captures perfectly the fact that we have now and finally entered into the digital era, and that the traditional constructs of ADR must adapt to this new environment right now. As an ADR community, we have long pontificated over the utility of alternative dispute resolution and technology as a means to more efficiently resolve disputes. Improving technology within arbitration itself has been seen as a nice to have, but stepped over time and time again over the decades with other pressing demands and priorities. Equally, ADR, which in this particular context excludes arbitration, has also been seen as a nice idea, which is sometimes engaged but traditionally has not been regularly publicized or seen as the norm for commercial dispute resolution, not to mention investor-state dispute settlement. With the pandemic, necessity has brought us to this moment. In order to access justice, we have set up virtual hearings in order to keep the courts open. In order to dispense of justice, we have let go of the traditional expectations of a physical hearing and adjudicate disputes remotely. And in order to relieve the backlog of court cases overwhelming the docket, we have reintroduced ADR tools to resolve disputes quickly and out of the more popular adjudicatory forums. At first, the use of technology was met with resistance. Due process concerns, lack of trust as to what was on the other side of the screen, not being able to see the whites of people's eyes. Pushback excuses of this nature filled the submissions, and oftentimes the adjudicators appeased those who challenged the traditional formats of in-person hearings. Postponing in-person hearings proved to be an unhelpful solution as the pandemic continued, and indeed continues for longer than anticipated. Gradually, and with the support of various organizations, as well as courts, practitioners, and even psychologists reviewing these types of excuses, the adjudicators became more proactive and decisive with granting virtual hearings. Looking at the dispute resolution landscape today then, and 2 years after we entered into this period of the pandemic, it would be worth taking stock as to where things stand. As you well know, in the Philippines itself, the Supreme Court institutionalized video conference proceedings for all of its courts using Microsoft 365. Noting that for the first time in its 119-year history, the Philippine judiciary has blazed a new trail by allowing remote testimony from parties situated in different parts of the nation and the globe. With people gaining access to the internet and accustomed to technology, virtual access to justice is here now a reality. This type of solution has been seen in court systems around the world, and I expect that the use of video conferencing within national courts will be here to stay. Importantly, and with the establishment of the technological information to keep courts open and justice accessible, the momentum will only go in one direction, which is further enhancement of technology to ensure that the virtual doors of the courts remain open. Secondly, with regard to arbitration, there is ready acceptance of the virtual modality for many aspects of the arbitral process. There is general consensus that case management conferences and other short procedural hearings will be able to be handled virtually going forward. Even for those who remain skeptical, clients themselves now see the benefit of virtual hearings and thus now direct their counsel to bear in mind the savings of cost and time for such short hearings. The other aspect, of course, is more availability of the users and the business side of the clients themselves to engage more and involve themselves more in the dispute resolution process, which incidentally has been seen by a recent study done by the ICC Task Force on ADR and arbitration, of which I chair, has been seen to enhance the potential for settlement. That is, by engaging the users and the business people within the companies that are in dispute, there is more potential for settlement. And adjudicators themselves are well equipped with protocols and the like to ensure that virtual hearings can be conducted seamlessly and take into consideration some of the concerns raised by the reluctant. And of course, institutions have pivoted quickly as well, offering online hearing services to ensure that the technology is handled by a neutral third party and operating seamlessly. But what about the other traditional forms of technology? What lies at the crossroads between such forms of ADR and technology? Indeed, the synergy between the traditional ADR form and technology. In fact, the two have really blossomed during the pandemic, and technology has accelerated the popularization of ADR. With other factors such as the event of the Singapore Mediation Convention and the reliance that courts have placed on ADR mechanisms as a urgency or emergency forum for dispute resolution during the pandemic, this is now the moment, right now, and to borrow a popular 80s hard rock lyric from Van Halen, right now, it's your tomorrow, ADR. In particular, mediation. This is the magic moment. In a recent survey conducted by this ICC Task Force survey that I'm chairing, companies indicated that mediation is the most commonly used method of ADR, with 60% choosing such means of resolving disputes, followed by arbitration and then settlement conferences in the context of litigation and arbitration. This, to me, indicates that mediation is already more popular than meets the eye. One of the key explanations for this is the lack of statistical information as to when mediation occurs and to what extent it is successful. Given the informal nature of mediation, there is oftentimes seen to be little need for a neutral administrative institution to be engaged and therefore keep track of usage of mediation. In addition, there are very few forums that exclusively promote mediation, unlike arbitration. Arbitration as an industry is well supported not only by the institutions, arbitrators, and counsel alike in the promotion of mediation and arbitration, in its promotion and development. However, since the pandemic, mediation and other forms of ADR have come into the fore. With an inherent flexibility in process and structure, mediation is arguably more adaptable to the changing needs of its users, and in this period, more ready to adopt the many functions that technology can bring to meet the demands of mediation. Thus, with a tech-savvy mediator who can conduct the mediation seamlessly, both in substance, but also by utilizing the many features of video conferencing software, such as breakout rooms, whiteboards, one-on-one meetings, etc., all of these tools, if used well, can lead to great time and cost savings. Now, recognizing the great potential of technology to enhance the traditional ADR systems, how much can we further progress this synergy? Looking at the work of the ICC Task Force on Arbitration and ADR, I propose a key number of key areas of further development. First, artificial intelligence. We have all seen AI in the movies and know that this has been a fairly common topic in arbitration circles. However, how often is ADI actually being used by stakeholders? AI, in the context of formulating a decision tree analysis and performing early preliminary case management assessments, is a tool that has been explored by some, but generally only for the company disputes. The technology at this stage is often seen as inaccessible to the average commercial dispute given the price point. However, this type of technology is not one that should be underestimated and should be kept at a minimum, should at a minimum be kept in view and really should be proactively explored. By developing appropriate AI for common disputes, not just the small consumer disputes or the massive the company disputes, we have the ability to significantly decrease and save time and costs by using and minimizing the number of issues that have to be dealt with in the context of a dispute. The second concept or second idea is our ADR platforms. Now, there has long been discussion on online dispute resolution in the context of arbitration. However, despite these discussions, most arbitral institutions have not been able to devise a seamless forum which instills confidence in both the users and the adjudicators to use any existing online dispute resolution system as a matter of course. The Stockholm Chamber of Commerce ODR system is perhaps the most advanced system of those being developed by the institutions. But even the SEC is not seen to be used as a default. SEC platform is not seen to be used as a default. Institutions must grapple with overcoming this hurdle and finding a truly a way to integrate ODR with all forms of dispute resolution. Mediation is perhaps the ideal candidate for testing out ADR. Again, with its flexible process, there is great gain to be had in utilizing ODR in lieu of paper exchanges and inefficient attachments of emails to communicate. We have already seen some systems, such as Microsoft Teams and Slack, offer platform for chatting, document sharing, etc. And with a few tweaks, such platforms could be easily adapted to fit the needs of parties engaged in mediation. Finally, and perhaps easiest to adapt, is that of a full IT support service for virtual ADR hearings. By outsourcing this piece, mediators can focus on their work as a mediator and not necessarily as a technology conductor. This is perhaps the easiest of the three proposed ways in which to utilize technology. Indeed, much of this is already being done. However, the institutions or the developers that are able to develop a hearing platform that is expressly tailored for dispute resolution of all kinds, arbitration, mediation, and further alternative dispute resolution mechanisms will gain significant traction. The costs will likely be minimal as compared to with any hearing facility one might rent, and importantly, one will be able to access expert mediators and arbitrators from around the world more easily. Now, I share but a few ideas as to how ADR and technology might go hand in hand. Admittedly, none of these ideas are complex or terribly novel. The takeaway, however, is that the moment is now. Right now, it's your tomorrow. No longer can we push back on these technological developments down the list of priorities. If we don't act during this period, we will see ourselves slipping back to the traditional ways of resolving disputes and lose the momentum for change. What does this mean for you? Invest in technology and use it in your work. As with everything, the talking about it will only get us halfway there. There is a real need to implement and not wait until the next until the next technology is perfected. Technology is ever evolving, as we know, and so one must be conscious that things change. But that is not a reason to not engage. With the staggered and uncertain timing of countries opening up for travel, especially as we are seeing this new variant take its toll, we must find a sustainable means to resolve disputes and virtually open our borders for engagement. I conclude with the final call again to the government, to the private stakeholders, and to the users. Do not let this moment pass. We can change the course of dispute resolution if we engage and bring all of our skeptics along with us in the process. Thank you very much.
Thank you very much, Ms. Chian Bao of the International Court of Arbitration, for your inspiring keynote message. Last year, we introduced to you the revitalization of the Office for Alternative Dispute Resolution, or the OADR, through the leadership of our inaugural Executive Director 5, Attorney Irene D.T. Alogok, during the first ever NADRC. In this year's convention, the OADR Executive Director will provide the recent developments, policy, and program updates on the Philippine ADR as spearheaded by the agency. To present the 2021 report, let me introduce the Executive Director of the Office for Alternative Dispute Resolution, Attorney Irene D.T. Alogok. Attorney Irene is the inaugural Executive Director 5 of the Office for Alternative Dispute Resolution, an attached agency of the Department of Justice. She is a professor at the New Era University College of Law and Tarlac State University School of Law. She formerly served as secretary and member of the board of directors of the Association of Government Internal Auditors Incorporated. She delivers lectures in mandatory continuing legal education covering topics in alternative dispute resolution. Attorney Irene is a trained government manager and a career executive service eligible. She has over 10 years of extensive law practice and has held key positions in all three branches of the government. Her passion for public service and desire to innovate is evident in her dynamic government service record, which includes her appointment as Acting Director 4 of the Internal Audit Service of the Department of Agriculture, her designation as Court Attorney 5 at the Judicial and Bar Council, and as Director 2 at the House of Representatives Electoral Tribunal prior to her appointment to her present position. She had her training on strategic conflict management for professionals at the Singapore Mediation Center and on comprehensive course on international arbitration under the Chartered Institute of Arbitrators, New York branch, and the Columbia Law School. She is also a trained arbitrator of the Philippine Dispute Resolution Center Incorporated. Attorney Irene represents the Philippines as one of the delegates to the United Nations Commission on International Trade Law, or UNCITRAL, Arbitration and Conciliation, or Dispute Settlement, and Investor State Dispute Settlement Reform. Attorney Irene obtained her law degree from the Aureliano University School of Law and Bachelor of Arts degree in Legal Management from the University of Santo Tomas. She is also a test certified bread and pastry chef. Attorney Irene is the author of the book titled Philippine Alternative Dispute Resolution, which highlights the different ADR mechanisms and practices in the country, like arbitration, mediation, ADR in the judiciary, ADR under the Katarungan Pambarangay system, ADR practice of indigenous peoples, and other ADR forms. Her book, which features simplified illustrations of pertinent legal provisions, updated rules and procedure, relevant jurisprudence and DOJ opinions, sample pleadings, and legal forms aims to keep readers abreast with the latest developments in ADR. Ladies and gentlemen, let us all welcome the OADR Executive Director, Attorney Irene D.T. Alogok.
of justice with promoting, developing, and expanding the use of ADR in the private and public sectors. Additionally, the law mandated the development of training standards for ADR practitioners and providers, certification, as well as the development, implementation, monitoring, and evaluation of government ADR programs. From the agency's founding, it has discharged its mission with prudence, and it has accomplished increasingly significant progress since President Rodrigo Roa Duterte appointed its inaugural Executive Director 5 in January 2020. Since 2020, the OADR has achieved substantial results in its main frontline services, consistently meeting and exceeding its annual targets. A total of 1,917 individuals have received training in the fundamentals of mediation, arbitration, and the Katarungang Pambarangay. For the same period, 100% of applications were processed within the specified time frame, resulting in the accreditation of 7 private ADR provider organizations, 1 public ADR program, and 19 individual ADR practitioners. Additionally, the OADR has recognized 149 ADR neutrals from accredited provider organizations and public ADR programs. Following the transition of advocacy activities from face-to-face to online, engagement has been particularly high. Among the highlights is the 97,211 registered participants who attended OADR webinars. The OADR accredited ADR providers were also able to provide substantial services to their stakeholders. The table presented indicates the ADR providers handled a total of 427 cases via arbitration and mediation, including annual carryovers. Meanwhile, 2,834 participants took part in training courses offered by accredited ADR provider organizations and neutrals. Along with the aforementioned figures, the OADR also pursued critical activities as part of its interim roadmap until 2022. The office has completed the revised fee structure for OADR services, ADR program management guidelines for the executive branch, and initial monitoring systems for executive agencies and accredited ADR providers. The OADR is presently transitioning to full attached agency operations in compliance with the 2004 ADR Act. In preparation for the projected accreditation in the coming months, the office has also implemented the ISO 9001:2015 Quality Management System. ADR training programs are likewise developed in partnership with relevant stakeholders and government entities, including the incorporation of internship standards. Last October, the OADR signed a memorandum of agreement with the Integrated Bar of the Philippines to strengthen collaboration and promote ADR practice to lawyers. Other significant institutional engagements are being formalized, including those with the Philippine Judicial Academy, the Department of the Interior and Local Government, Department of Trade and Industry, Public Attorney's Office, and the City of Manila, among others. Other notable developments in the use of ADR in governance have occurred alongside the OADR's program and policy activities. In the House of Representatives, there is an Internet Transactions Bill that includes the creation of a national online dispute resolution system for e-commerce. In addition, the Department of Trade and Industry has commenced the development of an integrated national online dispute resolution system for consumer protection. Another recent breakthrough is the Securities and Exchange Commission's ongoing development of its guidelines for intercorporate disputes in accordance with the revised Corporation Code. Executive Order Number 97, Series of 2012, revoked Executive Order Number 523, Series of 2006, and transferred the functions of the Office of the President to the OADR with respect to coordination, development, evaluation, management, and oversight of the ADR programs in the Executive Department. This comprises all departments, administrative offices, quasi-judicial institutions, and corporations that are owned or controlled by the government. Under the same executive order, all agencies are mandated to continue to promote the use of ADR, such as, but not limited to, arbitration, mediation, conciliation, and early neutral evaluation as part of their practice in resolving the disputes filed before them. To ensure proper assessment and evaluation of ADR program implementation within the Executive Department, government agencies are likewise mandated to submit periodic reports to the OADR regarding their compliance with Executive Order Number 523 directives, including details about any ADR program implemented in their respective offices, as well as the designated senior official and alternate responsible for ADR. Early this year, the executive branch agencies were formally requested to submit calendar year 2020 reports on ADR programs and procedures. The request was made via letters from the Secretary of Justice for 22 department-level agencies and from the OADR Executive Director for 295 non-government organizations and government-owned or controlled corporations. As shown in the table, submissions were received from 216 agencies. Based on the reports, 113 agencies were assessed to have functional programs or procedures in calendar year 2020 with ADR systems defined under the ADR law. Most of the ADR programs and procedures reported relate to mediation or conciliation, which include dispute resolution involving external parties and agency personnel. Several agencies use other forms of ADR, particularly arbitration, negotiation, customary laws, and community stakeholder dialogue. The number of reported cases that were settled through mediation and conciliation totals 166,331. The term public free legal assistance mostly refers to matters handled by the Public Attorney's Office and the DOJ Action Center that result in settlements or agreements. The Department of Agrarian Reform, the Department of Environment and Natural Resources, and the Human Settlements Adjudication Commission have successfully mediated land and real property disputes. Consumer protection refers to those cases mediated by the Department of Trade and Industry concerning consumer products and services. Labor dispute mediation covers employee-employer complaints handled by the Department of Labor and Employment and its attached agencies, as well as the Special Economic Zone agencies. Mediation for restorative justice refers to the mediations for offenders and victims as administered by the Parole and Probation Administration under the Department of Justice. Mediation involving higher education institutions refers to dispute settlement handled by the Commission on Higher Education in response to complaints lodged with it. Data privacy refers to mediations conducted by the National Privacy Commission on Data Privacy Act issues. The Intellectual Property Office of the Philippines, the first government agency to apply for and be recognized for accreditation and certification, oversees intellectual property mediation. The Games and Amusement Board also offers mediation to disputing parties who fall within the scope of the agency's regulatory authority. In terms of arbitration, reported data reflects that a total of 597 cases were resolved in the areas of labor, construction, government procurement, power, and sports. These numbers were provided by the Department of Labor and Employment, Construction Industry Arbitration Commission, Department of Budget and Management Procurement Service, Power Sector Assets and Liabilities Management Corporation, and the Games and Amusement Board. The mediation and arbitration statistics in the executive branch constitute much of the reported data in the calendar year 2020 ADR programs and procedures, particularly in relation to key government functions. Executive Order Number 78, Series of 2012, was enacted to promote the use of ADR by making the resolution of disputes arising out of a contract less expensive, tedious, complex, and time-consuming, thereby creating a more inviting climate for private investments in the country. Under this executive order, all contracts involving public-private partnerships, build, operate, and transfer law, and joint venture agreements between the government and private entities must include provisions on the use of ADR mechanisms at the option and upon agreement of the contracting parties. Similar contracts entered into by the local government units are encouraged to stipulate the same provisions in accordance with their own rules, guidelines, or procedure. To raise awareness on the provisions of the executive order, the OADR and National Economic and Development Authority are tasked to conduct massive information campaign about the policy and ADR. In accordance with this order, the OADR has included Executive Order Number 78 as one of the topics in episodes of the OADR webinar series, the agency's flagship online advocacy program. Furthermore, virtual ADR roadshows were held for provinces of Region 4A to encourage the use of ADR in local government units. Discussions on Executive Order Number 78 were included in the course of these activities. As the OADR moves to fully independent attached agency operations in 2022, it is also preparing for the realization of the following plans for the future of ADR in the Philippines. First, mainstream ADR as the primary method of resolving conflicts instead of adversarial court proceedings and administrative adjudication to increase access to justice, facilitate conflict resolution, and improve governance in accordance with ADR standards and applicable laws, rules, and regulations. Second, encourage and optimize the use of established government ADR procedures for dispute resolution at the national, municipal, and institutional levels. Third, establish regional, municipal, and institutional level ADR procedures that are guided by higher authorities or oversight agencies as appropriate. Fourth, recommend the development, adoption, and/or improvement of ADR policies as part of agency reports to the OADR pursuant to Executive Order Number 97, Series of 2012. Fifth, to promote in the public and private sectors the services of the OADR and its accredited ADR providers and practitioners. Sixth, formulate and issue operational guidelines for Department Circular Number 49 to provide details on accreditation and compliance monitoring, including the following: frontline service procedures for accreditation and approval of training programs, compliance monitoring procedures, including complaints filed before the OADR regarding accredited ADR providers and revocation of accreditation due to violations, OADR approval and monitoring of APO-provided basic training and accreditation program for ADR neutrals offered to non-governmental institutions. 7. Continually improve accreditation and compliance monitoring procedures pursuant to the Ease of Doing Business and Efficient Government Service Delivery Act, and in accordance with the requirements of Department Circular Number 49. 8. Include in the formulation of amendments to the ADR Act and administrative issuances the updating of ADR quality assurance mechanisms. Thank you.
Thank you very much, ED Irene, for that notable and comprehensive report. We are also pleased to present in this convention the OADR Advisory Council's 2021 report on the policy directions and efforts to bring the ADR practice, community, and programs to greater heights. This is pursuant to the implementing rules and regulations of the Philippine ADR Act of 2004 and the Justice Department Circular, providing for the reconstitution of the OADR Advisory Council. The Council is tasked to provide advisory assistance to the OADR Executive Director on policy, operations, and relevant matters on ADR. Thus, to give us this year's OADR Advisory Council's report, we have with us today the chairperson of the council himself. Ladies and gentlemen, let us all welcome the OADR Advisory Council chairperson, Attorney Domingo Igon Q. Cayosa.
Distinguished guests, fellow ADR practitioners, and advocates. Thank you for participating in this national convention and being one with us in promoting ADR, hopefully to overcome the notoriously slow justice system. Fellow ADR practitioners and advocates. Thank you for participating in this national convention and being one with us in promoting ADR, hopefully to overcome the notoriously slow justice system in our country and to benefit from the emerging global trend towards arbitration, negotiation, and mediation as viable, effective, and efficient methods of settling disputes. As chair of the OADR Advisory Council, allow me to share with you the accomplishments and milestones of the Advisory Council for the year 2021. At the beginning of 2021, the Council provided guidance to the Executive Director and her team in setting the strategic direction for the advocacy and promotion of ADR in both the government and the private sectors. distinguished guests, fellow ADR practitioners, and advocates. Thank you for participating in this national convention and being one with us in promoting ADR, hopefully to overcome the notoriously slow justice system in our country and to benefit from the emerging global trend towards negotiation and mediation as viable, effective, and efficient methods of settling disputes. As chair of the OADR Advisory Council, allow me to share with you the accomplishments and milestones of the Advisory Council for the year 2021. At the beginning of 2021, the Council provided guidance to the Executive Director and her team in setting the strategic direction for the advocacy and promotion of ADR in both the government and the private sectors. The strategy map leads to an enlightened society, nurturing a non-litigious culture and allowing party autonomy in settling disputes fairly and justly. The map sets the directions for OADR in raising the standards of the mainstreaming ADR in the Philippines. The Council helped identify strategic outcomes for ADR practitioners. The Advisory Council provided valuable inputs in setting fees for the accreditation and certification of ADR practitioners and provider organizations. The fees were set with due regard to economic conditions, equity, minimum standards, and best practices. The Council will ensure that stakeholders' perspectives and aspirations are considered and translated into policies and issuances of government. We envision Philippine ADR practitioners and provider organizations to be at par with their international counterparts. For the local ADR to remain globally relevant and competitive, the principles of diversity and reciprocity were adopted. We may welcome practitioners from other jurisdictions as we support diversity in arbitrator panels and expect reciprocity in terms of cross-border practice. The Council provided guidance in setting standards in the training of ADR practitioners. The minimum standards ensure that certified or accredited ADR neutrals possess the basic knowledge and skills to serve as such. Accordingly, the OADR conducted various trainings on arbitration, mediation, and other ADR mechanisms under the Katarungang Pambarangay Law. We hope that the quality of training programs will be maintained and the standards of ADR practice to significantly improve. The Advisory Council supported cooperation with schools and universities inasmuch as legal education is crucial in the promotion of ADR processes and the development of ADR professionals. Collaboration with the academic community led to the first ever legal symposium with eminent scholars and academicians. One of the more important results is the cooperation with the Legal Education Board and the integration of ADR in the law curriculum, training of law professors on ADR, and conduct of other activities to encourage law students to consider ADR as a field of practice. The Council helped in recalibrating the compliance and monitoring guidelines of the OADR. The Council members gave insights on how these guidelines will impact practitioners and how to better and more effectively uphold state policy. These guidelines are to be firmly and proactively implemented to upgrade ADR quality in our country. In line with the provisions of DOJ Department Circular 98, Series of 2009, this is the IRR of the ADR Act of 2004. The OADR can provide the schedule of fees for ad hoc arbitration and mediation upon the agreement of the parties. The experienced council members shared data and their views on the usual charges and costs to the parties, the appropriate fees, while ensuring access to justice with due consideration for small business entities and individuals. Fees which are lower than industry rates may be adapted to encourage parties to consider ADR processes to settle their disputes. We are happy to note and we are pleased to report to you that the Office of the Alternative Dispute Resolution, your OADR, has been reorganized, enlarged, and rejuvenated with the support of no less than the Secretary of Justice, Secretary Maynard Guevara, and the dynamism of Executive Director Irene and her team. The Advisory Council will continue to provide guidance and advice to promote and improve ADR in our country. We look forward to more activities and meaningful outputs for OADR and our growing ADR community. Thank you for the honor and the opportunity to contribute to peace building, a culture of settling disputes amicably, and justice beliefs. Together, let us move forward faster with ADR. Maraming salamat po.
Thank you very much, Attorney Cayosa, for that informative report. Together with Attorney Cayosa, who also represents the Integrated Bar of the Philippines in the Advisory Council, are Mr. Tristan Besa, representing the mediation profession, Attorney Teodoro Calod Fort, representing the arbitration profession, Attorney Salvador Espanga Jr. from the ADR organization, and Attorney Gwen B. Grecia de Vera from the Academe. We will now proceed to the main portion of our program. With more activities done with the use of technology, we now look into the alternative dispute resolution, or ADR, in the digital world. To provide us a view of how technology redefined ADR in the world, let me introduce our first speaker, Professor Yoshihisa Hayakawa. Yoshihisa Hayakawa serves as a professor of law at Rikyo University, Tokyo. He also teaches and researches in a number of foreign universities, including Columbia University, Cornell University, QM College of University of London, and Australian National University. He also serves as a partner at Uryu and Itoga, Tokyo. He serves as a counsel in many cases of transnational litigation and international commercial arbitration. He also serves as a representative from Japan for a number of intergovernmental organizations, including UNCITRAL, APEC, ISO, and the Hague Conference on PIL. He holds positions as president of Japan National Committee of UIA, Japanese member for Commission on Arbitration, and ADR of ICC, a Japanese member of Users Council of SEAC, and arbitrator for Court of Arbitration for Sports. He is also an executive director and secretary general of Japan International Dispute Resolution Center. He also serves as chair of IT ODR section of Japan Federation of Bar Associations. Ladies and gentlemen, let us all welcome Professor Yoshihisa Hayakawa.
I'm sorry. I realized, the most frequently used term in 2021 is please unmute. And in my case, I'm so sorry about that. And but I'm just now unmuted, and so I will start my presentation today. And so please, show my slide. Thank you very much. And so the next, please. So today I'd like to explain about the present trial of the international organization of international lawmaking for the online dispute resolutions. First, UNCITRAL, and secondly, APEC, and thirdly, ISO. But let me explain something as an introduction. Next, please. So the e-commerce has drastically increased worldwide in the present digital world. The wide use of e-commerce has increased the number of related disputes, including cross-border ones, since location of the parties does not mean anything in e-commerce transactions. And additionally, in the online shopping, average of the order value of consumers is approximately more or less 500 US dollar. At the time of dispute, litigation or traditional alternative dispute resolution ADR cannot substantially resolve the disputes, especially cross-border ones. In other words, no one tried to file an international litigation for 500 US dollar dispute, or no one also does not use ADR if two parties located in different countries have to physically meet for the dispute resolution. So now ADR systems using online for the easy and speedy dispute resolution have been gradually and widely used for e-commerce related dispute in the digital world. It is called as online dispute resolution or ODR. So ODR has been used in the various fields as an efficient tool for dispute resolution in the United States. So many people are now using ODR by their own smartphone and using chat box, and they can easily resolve the disputes. EU has established its ODR regulations in 2013 and has encouraged the use of ODR in the territory. And even in Japan, ODR has become an important issue to be discussed in the government and the Japan Federation of Bar Association since 2019. So online shopping can easily become cross-border transactions, and cross-border disputes can easily happen. Next, please. So the now efforts for making international rules on ODR have studied for first, effective reactions to the cross-border low-value disputes in e-commerce. And secondly, we try to harmonize or try to achieve harmonization for the ODR schemes in various regions. And thirdly, we would like to assist smooth introduction of ODR even in the emerging market countries. Next, please. For this purpose, United Nations started its own ODR project, Ancestral ODR Working Group started. The first meeting was held in Vienna in 2010, and we have more than 10 meetings, and finally it ended 2016. Next, please. At the very beginning stage, so United Nations ODR uniform rules for B2B case and B2C cases were tried to establish. And at the time, so 3 steps approach was proposed. First one is a negotiation or comprehending. And secondly, it fails, we are moving to mediation or facilitated settlement. And if fails, we are going to the decision-making process, so-called arbitration. And all processes will be basically conducted by online-based document, and a simple and quick process for low-value disputes. It was tried to achieve. Next, please. And it means at the very beginning stage, the United Nations online arbitration rules were tried to establish. And in this scheme, the single arbitrator chosen by ODR arbitrator was proposed because we have to make a very efficient system for low-value cases. And all awards shall or should be in public on website, except private information. And it is very important for making big data. And the big data is necessary for the AI, artificial intelligence. So as a final goal, we try to establish the ODR scheme where AI could assist the decision maker or facilitator for the dispute resolutions. And substantial enforcement system by trust mark is also proposed. Honestly speaking, if the disputed amount is only just $500, even if we use ODR, which is very efficient one, but in the enforcement phase, we try to rely on the national court system. It will take time and cost. So it is almost nothing. So from this reason, the substantial enforcement or implementation system by trust mark is proposed at the time. So trust mark means the kind of the symbol, and the vendor, if the vendor would like to use the symbol, it means so that I will follow the final decision making and the final decision, and I will voluntarily implement the final outcome. And if the vendor failed to implement, it means the trust mark will be removed. So using such kind of the market mechanism, so that we try to establish the substantial implementation or enforcement systems. And at the same time, the worldwide uniform rules for the merit should be established. That is another proposal at the very beginning time. In the cross-border cases, we have to face the very complicated choice of law problems. I'm a professor of private international law. This is my expertise. But it is because I know the complicated private international law issue is one of the obstacles for the smooth and efficient dispute resolutions. So if we could agree upon the single the rules for the merit in advance, so that we could or arbitrator could use such kind of the substantive rules for the dispute resolution, and they can avoid the complicated choice of law or private international law problems. Next, please. But gradually, a serious issue appeared. The problem is the validity of the arbitration agreement between the consumer and the business corporations. In one group, United States and other countries, they said, of course, it should be valid, even if the case is a B2C case. But EU, Japan, and other countries in other groups, so that they said consumers should have a cancel right of the arbitration agreement, especially for the B2C case. Next, please. So the EU has established its own ADR Directive 2013 and ODR regulations at the same year. And they said, since a consumer should not be removed its fundamental right to go to court, the consumer shall have a right to cancel the pre-dispute arbitration agreement. But unfortunately, United States and other countries, strongly refute this kind of proposal. So that there is a big debate between the two groups in the United Nations. Next, please. And finally, we gave up, establish the United Nations ODR rules, legal one. And the working group terminated in 2016. And the United Nations Commission adopted the technical note on ODR. So next, please. So what is the ancestral technical notes on ODR? So it explains the important elements of the ODR system and which kind of the rules should be established. But this note itself has no legal effect. And additionally, it explains that we should have 3 steps: negotiation, mediation, and arbitration. But I'm sorry, negotiation, mediation, and the final stage. But there is no explanation about the final stage, 3rd steps, because there is a big dispute between the United States group and the European groups. So the next, please. So the EU is now establishing its own ODR platform, but other countries still need uniform rules and schemes for the global ODR platform with negotiation and the third parties' interventions. So after the break in the United Nations in 2016, from the 2017, APEC, Asian Pacific Economic Cooperation, started its own project to establish another global ODR platform. So the UNCITRAL and UNIDROIT assisted the APEC project on ODR. And at the very beginning of the meeting, the B2C issues should be avoided. It was proposed, at least at the very beginning stage, because we experienced in the United Nations. So the B2C cases, many countries or various countries have various policies. So that we should start at the very beginning, B2B rules, and think about the B2C rules in the later stage. So that is the direction of the APEC project. Next, please. So this is the history of the APEC ODR project. So the 2017 a formal proposal was held in Vietnam. And so we have in 2018 in Papua New Guinea, we have several workshops and meetings, formal meetings. And 2019 in Chile, we have a meeting and a workshop. So the workshop was held in Japan. And 2020, unfortunately, we faced the COVID-19 situation. So the meeting was held online. But gradually, we progressed this project. Next, please. And first of all, APEC does not intend to establish a central authority for ODR or to encourage each member to establish a central authority for ODR. Instead, APEC encourages member states, member economies to collaborate for the world use of ODR and provides model procedure rules and encourage many ODR providers to join the APEC collaborative framework on ODR. And what is the APEC collaborative framework on ODR? So it aims to assist member economies to encourage the use of ODR and potential business cooperation users in the APEC region, including e-commerce market providers, to actively use ODR. Next, please. So the academic institutions in the APEC region assist to maintain a web page on the satellite website of APEC where the list of ODR service providers adapting APEC model procedure rules on ODR is presented. And the satellite website on APEC ODR is working now, the https www.apec.org/SERI, SERI. SERI is a driving force inside the organization in the APEC, and I'm serving as a co-vener of these organizations. And this satellite website includes overviews and a list of opt-in economies, now China and Hong Kong, China, Japan, Singapore, and the United States, and the list of ODR providers. This is under construction, but it will be soon presented. And with a list of ODR providers, the users or customers can easily find what kind of the ODR providers are reliable. So after the summer of 2021, we had 4 series of seminars. The first seminar on satellite website for ODR, and the second one for the opting in issues, and the third one is the ODR provider to be listed. And the fourth one is how ODR works for MSMEs. And we will have a very large-scale workshop on ODR in Tokyo in 2022, February 16 to 18. Why not join this, the large-scale workshop? And perhaps, the almost all ODR providers now working gather together and exchange the information. And so each economy from APEC member economies delegate will discuss how we much more strongly encourage the use of ODR. And many of the demonstrations of the ODR will be presented. And in addition, the United States is trying to organize another workshop or webinars, a webinar on secure transaction and ODR in December 2020. And 2022 spring, the workshop on secure transaction and ODR will be held. Next, please. So in this ODR project in APEC, in fact, many ODR events and projects have been organized in APEC regions, including in Hong Kong. So there are 2 sessions in the Hong Kong Legal Week on ODR in 2021, and IGLIP on ODR, which is a kind of the commission of the knowledgeable people or experts in Hong Kong was held. And in China, ODR seminar by Shanghai International Visitor Center was held in November 2021. And ODR services was actually provided by the Guangzhou Arbitration Commissions. And in Japan, a governmental committee on ODR is working now very actively. And in Philippines, I'm now attending the Digital World, ADR in Digital World session. So ODR is one of the important topic. So Indonesia and Vietnam also started their own ODR project, I heard. So now ODR is booming in the Asian regions as well. So next, please. And I'd like to turn to another project in ISO, International Organization for Standardizations. So a project for TC321, which is called the TC321 project, has started in ISO as below. So for the standardization in the field of transaction assurance in e-commerce, related upstream, downstream processes, including the following, and you can see the important issues to be established is the protection of online consumer rights, including both prevention of online disputes and resolution process. Next, please. So the project for TC321 was proposed by China, and Japan is now trying to use this ISO standard as a trust mark for the implementation of arbitral award or similar decisions issued in the scheme of ODR. So the ISO is very famous for the the kind of the this type of the trust mark. For example, environmental fields. The mark of ISO is a kind of the symbol that this the company is a environmental friendly company. Similarly, so if the company with the ISO ODR mark, it means that company or that e-commerce vendor is friendly to ODR, or it will follow the final outcome of ODR voluntarily. In other words, with the ISO project or ISO standards, we do not have to rely on the national court enforcement system of the final decision of ODR. So the November 2019 presentation from Japan was proposed, and 2020 we had several discussions, and finally 2021 a formal proposal for PWI. PWI is one of the steps of this ISO project, and it was the proposed formally. And now we are about to face the ballot. And after the ballot, this project is becoming the formal one. Next, please. So it is aimed to provide ISO standards, including basic principle of ODR and technical conditions and operational manuals. And the target is e-commerce operators, including e-commerce platform operators, which try to develop their own ODR service, and the ODR service provider as well. That should be outsourced by e-commerce operator or e-commerce vendors. Next, please. And the following documents are to be referred because there are similar documents, and which is very excellent. And for basic principle, there is a very famous international organization with the experts. It is called the International Council for Online Dispute Resolution. And this ICODA have its own standards. And perhaps this is a very good example for the standard making process of ISO, especially for the basic principles. And for the technical conditions, for example, Canadian CRT, Civil Resolution Tribunal, have access to information and privacy policies document. So this CRT's document is also works as a very good example for the standard making process of ISO. And for the operational manuals, so ancestral technical notes on ODR, online dispute resolution, is of course a good example. And model procedure rules for the APEC collaborative framework for ODR is also a good example. So honestly speaking, the model procedure rules for the APEC collaborative framework for ODR is substantially similar or same as the final draft of the ancestral model procedure rules. But unfortunately, I explained the history. The final draft did not appear as a formal text of ancestral, but it revived in the APEC project. So these documents are similarly very alike each other, And these documents could be work as an example for the standard making process of the operational manuals. So next, please. So the image of the basic principle is like this. So the for the ODR, so the accessibility or accountability or competent, confidential, equality, fair, impartial, neutral, and legal, and secure and transparent. So these elements are very important. So the we will establish much more details of the these elements or additional ones. Next, please. And ODR have to be secured, and especially from the viewpoint of the privacy or information security. So the protection, protecting the personal information privacy, or anonymization of decisions, or record sealing, or security and storage of records, and access to records. So this kind of the issues should be the standardized, and so we try to provide a document which everybody can easily rely on in ISO standard. Next, please. So image of the operation manuals are like this. So the general provision and the communication, notice, response. This is a very normal process of the ADR. And the negotiation stage, and the mediation stage, and the arbitration or non-binding arbitration, in other words, adjudication stage. And so these stage needs a collection of decision and the settlement and appointment neutral, and legislation replacement of the neutral, and power of the neutral, and the other, the important issues. Next, please. So now ISO just started this project, and we are now in the preliminary stage. And I guess in next year we are moving to the NP stage, new work item proposal stage, and within next year we are moving to additional working draft stage, and we wish that we will finish our work within 3 years. So that, in other words, within 3 years, we can have the new ISO standards for ODR, and with which many of the ODR provider or e-commerce vendor can easily use ODR, and so many of the customers and consumers can easily rely on such a reliable ODR. So these are the presently working or progressing the projects for the ODR or online dispute resolution for the coming perfect digital world. So next, please. So this is the end of my presentation, and my email is haya@rikyo.ac.jp. If you have a question about this project and other related issues, please do not hesitate to contact me by this email. Thank you very much. This is the end of my presentation. Thank you.
Thank you very much, Professor Yoshihisa Hayakawa, for that comprehensive lecture. For the information of our participants, our speakers will join us again later for the panel discussion. We encourage everyone to reserve your questions for later, where our panelists may address them within the allotted time. For our next speaker on ADR in the digital world, let me introduce Mr. Putu Prima Apri Swajaya. Mr. Apri Swajaya has worked as the Consumer Protection Officer for the ASEAN Secretariat since April 2020. Previously, he was the COO of Glexindo, a B2B e-commerce startup in Indonesia, and has worked as a business consultant for Australian Indonesian Partnership for Promotion Rural Income through support for markets in agriculture. Ladies and gentlemen, let us all welcome Mr. Putu Prima Apri Swajaya.
Thank you very much. Good morning and good afternoon. Honorable Manardo E. Guevara, Secretary, Department of Justice. Ms. Chan Bao, Vice President of International Court of Arbitration, International Chambers of Commerce. Attorney Irene D.T. Alagok, Executive Director of the Office for Alternative Dispute Resolution, or OADR, in the Department of Justice. Attorney Domingo Egon Q. Cayosa, Chairperson of the OADR Advisory Council, and Professor Yoshihisa Hayakawa, Professor of Law in Rico University, partner of Uryu and Itoga, representative of Japan, UNCITRAL, and IPAC. My fellow distinguished speakers and distinguished guest speakers and participants, ladies and gentlemen. It is with great pleasure and honor for me to deliver the presentation on behalf of my colleague, Mr. Louis Tek Hyong, the Head of Competition, Consumer Protection, and IPR Division of the ASEAN Secretariat. As the ASEAN Consumer Protection Officer, I work closely with the ASEAN Committee of Consumer Protection, or ACCP, especially on matters such as online dispute resolution, or ODR. Could I see my presentation, please? Thank you. Given the importance of ODR in a growing digital economy, let me share with you the initiatives taken by the ASEAN to address the growing importance of ADR in the digital world and how technology has defined ADR. Firstly, let's underscore the ASEAN High-Level Principles of Consumer Protection, or AHL-PCP, which amongst others provide the guiding principles for consumer protection in ASEAN. Especially, I would like to draw your attention on Principle 4 of the AHL-PCP, which is consumers have access to appropriate and convenient sources of advice and redress, including alternative dispute resolution, or ADR. And Principle 8, consumers and e-commerce are protected. So next slide, please. At the 53rd ASEAN Economic Ministers, or AEM, meeting on 8 to 9 September 2021, the ministers considered the strategies and steps needed to accelerate ASEAN's economic recovery, digital economy integration, and the work plan for the implementation of the now endorsed ASEAN Agreement on e-commerce. The consolidated strategy of the ASEAN Fourth Industrial Revolution, or 4IR, was discussed. Amongst other, the ODR, being the online version of the ADR, are considered instrumental to maximize growth potential to digital trade in ASEAN, as it helps spur the growth of e-commerce and still consumer confidence in the digital economy. At the AEM, the ASEAN Digital Integration Framework Action Plan, or DFAP, 2019 and 2025 was launched together with the ASEAN Digital Integration Index, or the ADII. Together, they serve an action plan and an index which can be used to measure the progress of digital integration of trade services in ASEAN. The AEM endorsed the Bandar Sri Begawan Roadmap, or BSBR, an ASEAN digital transformation agenda to accelerate ASEAN's economic recovery and digital economic integration. In the BSBR, the ASEAN ODR network is identified as part of Phase 2, Measure 1, which is to accelerate existing work in the area of trade facilitation and digitalization, which calls for the development and implementation of the ASEAN ODR mechanism for cross-border consumer complaints. Next slide, please. Your Excellency, ladies and gentlemen, let me highlight to you specific deliverables under our ASEAN Strategic Action Plan on Consumer Protection, or the ASAPCP, from 2016 to 2025, that deals with the development of ODR in ASEAN. Other than the two high-level principles mentioned earlier, being part of the AHLPCP, set as Initiative 1.1.1 of the ASA, we are to achieve Outcome 3.2, establish the ASEAN ODR, or Regional ODR Network, by implementing three specific initiatives. These are namely Initiative 3.2.1, which is to establish a national ODR system, Initiative 3.2.2, to establish the ASEAN ODR network, and Initiative 3.2.3, which is to establish the ASEAN mechanism for cross-border complaints and investigations. These initiatives are supplemented by a now completed Initiative 1.6.1 to develop the guidelines to common approaches on ADR for consumer protection and the feasibility study on the ASEAN ODR network. Having received confirmation that an ODR ASEAN network can be developed with multiple models, we are now developing an ASEAN ODR guidelines to help AMS to develop their respective ODR. Concurrently, we are also undertaking, as Initiative 2.1.1, is a study of the needs and gaps in AMS on the access of consumer redress or alternative dispute resolution. We also completed a pilot or trial run of the ASEAN Regional Complaint System as identified earlier in the BSBR. All these initiatives strive towards instituting high consumer confidence in the ASEAN economic community and cross-border commercial transaction as encapsulated in Strategic Goal 3 of our ASAPCP. When developed and if proven successful, the ASEAN ODR network can extend from B2C to B2B and can also be extended to other sectors. The ASEAN ODR guidelines, once completed, will set the benchmark for all AMS to establish their respective ODR, which will pave the way towards interoperability and convergence with harmonization of consumers' laws and policies under longer term. The ADR guidelines mentioned earlier assesses the different approaches to ADR in each AMS and recommends steps to facilitate its implementation. The Needs and Gap study will also help AMS consider reforms with its legal redress mechanism, e-commerce, fintech, and data protection sectors. Next slide, please. Now, this slide basically sets out the various complexity and degree of automation which the ODR system, the AMS may and can have. From simple, straightforward digital filing in a simple platform and to one hand to a highly sophisticated predictive automated justice that functions based on algorithm, AI, and deep learning, which can be data-driven without human intervention. Our ODR feasibility study informs us that it is not necessary that we should start off with a very sophisticated technology or advanced digital platform or fastest connectivity in order to establish a functional ODR system, domestically or regionally to service consumers with cross-border disputes. Using simple emails or having basic platforms to file regional consumer complaints, which is that automatically redistributed to participating AMS consumer protection agencies, as we have done under a pilot or trial study, is sufficient to streamline and manage the common nature of consumer complaints. Over time, of course, as the technology improve and become more advanced, accessible, and affordable, we can consider a system upgrade. And this was mentioned just this morning by Ms. Gianna Bao. And it cannot be ignored that we might be adopting this technology very soon. Next slide, please. Now, ultimately, and I don't want to dwell too long on this because I'm not really an expert on AI technology, but what we see is one of the things that we are most likely going to adapt in the very close future. Now, ultimately, what we want out of an ODR system is to help resolve consumer complaints and dispute as quick as and as accurate as possible. We have personally seen firsthand the substantial increase of complaints at the peak of the COVID-19 pandemic in 2020. This is mostly due to sudden fluctuation in price for essential goods, frauds, as well as the sudden increase of e-commerce transaction. At this very moment, many of our consumers protection agencies in ASEAN itself are already very overburdened by the amount of complaints received. You have seen, and I talked about it in our previous slide, that the start of the ODR, for the most part, will involve basically digitizing cases or complaints, eliminating hard copies, which will greatly benefit and ease AMS. However, this must evolve to a more automated system. anticipating a very steady increase in consumer demands and complaints received. Now, upgrading the system involves, of course, adopting an AI or an advanced algorithm that will help automate the process, which can be seen here in three different tiers. The first being the AI that helps to automate inquiry routing. Now, one of the biggest problems in receiving consumer disputes is that most are not within the purview of consumer protection agencies. Now, for example, an agency may receive a complaint that is B2B in nature. However, the agency may only deal with complaints that is B2C in nature. Now, the system itself will suggest the user to contact another agency that may help the consumer. Um, Next tier is the chatbot or the previous slide, please. Sorry, thank you. Next tier is the previous slide, please. Thank you. Next tier is the chatbot or robot lawyers. Although most chatbots are still considered quite rudimentary as they are scripted to answer certain questions and domain, for example, such as automotive products only consumer products. It is still very useful to help companies manage their customer service, providing users 24/7 self-help facility to resolve disputes. Users would at least know if they are eligible for a case before submitting disputes, subject to laws upheld by the current country. Now, for example, in this case is Singapore and with their lemon law. The lemon law is a provision where a consumer can make claim for defective products sold to him or her within 6 months of purchase. Should the user inform the bot that he wants to raise the dispute before the 6-month cutoff time, the bot will simply let them know that it is past the cutoff time. Thus, there's no case because it is beyond the jurisdiction of the Consumer Protection Agency. The user may not know such law, thus the bot will inform them. However, if we talk about robot lawyers, on the other hand, they are supposedly more advanced than chatbots as they utilize more advanced deep learning AI technology to help consumer disputes from wider range of domains. So not limited to just one or two, but maybe to more bigger range which can help consumers with. And then we have predictive justice. As the name implies, predictive justice would allow businesses and consumers to get a glimpse of what the result would be should they bring the dispute to court. This is a very futuristic system that will simulate and solve cases based on the past data of similar cases to predict possible outcomes. The result of the predictive justice will advise both parties to decide whether they should go to court or not, and help identify common cases where a resolution can be achieved almost instantly. All these systems of AI can be very useful to help either sift out disputes not related to the agency or assist to expedite resolving common law or value disputes, allowing consumer protection agencies to focus on the more difficult cases that their system could not solve. But it must be kept in mind that the decision making still lies with us humans, while the robots handles the very easy automated jobs. It must also be noted that to have such a technology to function correctly in the first place, the initial ODR must be able to collect and capture disputes online and create a digital database for the AI to access. Next slide, please. Now, Your Excellency, ladies and gentlemen, so I would like to show you exactly what the ASEAN ODR network looks like. In theory, it should be something modular, similar to the puzzle shown here, with each different puzzle pieces representing an important segment of the economic landscape. These are the traditional offline modes of dispute resolution, including a non-litigation channel, businesses and consumer association, the available ODR mechanism for specific sectors such as finance, food, safety, or tourism, and the utilization of the ACCP website. In other words, there is a built-in interoperability from the design stage. The ACCP focal points will be responsible to coordinate and refer across and within countries, engage with facilitation and mediation, especially those involving vulnerable consumers, and data management. This modular design can be stacked up once the ODR are expanded to other sectors and new industries. Next slide, please. Now, permit me to explain, and apologies if it's a bit small in the slideshow, but Permit me to explain the vision of the ASEAN ODR network by way of a colored panel flow chart. In a nutshell, the blue panel refers to the regional ODR network, which is headed by the ACCP focal points and the ASEAN Secretariat. It is connected to the AMS, National ODR, in the orange panel, and the respective sub-national ODR in the green panel, comprising of usual consumer protection agencies, sectoral authorities, consumer associations, ADR bodies, and tribunals. The white boxes refer to traditional ADR with bricks and mortar setup, slowly being converted into online dispute resolution represented by the yellow boxes. This is an ongoing process happening in all AMS with different numbers of yellow and white boxes. The aim is eventually to convert the white boxes into yellow and eventually linked by the large yellow boxes in the blue regional panel. Next slide, please. Now, I'd like to elaborate a little on the process of the ODR system, which has been developed by some AMS, and add to what have been discussed. A good example is the ODR developed by the Office of the Consumer Protection Board, or the OCPB of Thailand, which set up an online mediation platform which currently focuses on the automotive sector. Automotive sector. It is a pilot project where consumers may lodge their complaint through their website using a mobile application or offline means, such as the complaint center and hotline. The option for settlement through online mediation is voluntary. If both parties agree to use the online mediation, a mediator from the OCPB will approach them to set up a time and date for the virtual meeting. A confirmation along with a password for access will be communicated through SMS or email. If the mediation process is successful, the complaint will be terminated from the system and both parties will be required to sign an agreement. Whether or not the parties follow through with the agreement is closely monitored by the OCPB. On the other hand, if the initial mediation fails, another online mediator will be appointed to assist with the settlement of the complaint. Although this ODR system is currently still in a pilot phase, there are already plans to expand it to more sectors in industries once all technicalities are solved and an initial track record of successful mediation outcome has been established. The automotive sector was selected because of the high volume and value cases. The creation of this particular ODR mechanism is a good and humble start with the endpoint of eventually developing the ASEAN ODR network. And as mentioned earlier, recently the ACCP website, or the ASEAN Consumer, or if you like to go to our website, it's at aseanconsumer.org, piloted the ACCP Online Consumer Complaints function during the ASEAN Online Sale Day, or AOSD, which took place in August 2021. The pilot function allows consumer who has purchased products with ASEAN to lodge complaints through the ACCP website where focal points assigned to each AMS will be notified. The complaints can originate from any consumers around the world who has purchased a product from one of the AMS. Once the complaint is lodged, a consumer protection agency from AMS where the product originates will follow up with the complaint and commence their investigation until the dispute has been resolved. Next are on the AMS who are currently building their own, of course, is the Philippines with the Philippines Online Dispute Resolution System, or the PODRS, who envisage an online automated portal for consumer complaints and queries. Shifting from a manual and email referral system, the platform will allow consumers to track their complaints, processing in real time, and link up with the consumer-related agencies outside of the Department of Trade or Industry, or DTI, so that cases under their respective purview could be dealt with in a faster manner. Now, all of these systems do correspond with common criteria and recommendation of an initial ASEAN ODR mechanism design. If you'd like to know more about this, you may look through our ASEAN ODR feasibility studies, or FS, which is available to download to the aseanconsumer.org website. Others in the pipeline of being developed are Indonesia, which is linked with their e-commerce platform, and the cases are closely monitored, and the case of Vietnam, which the progress of dispute resolution can be tracked online regardless of location in the country, and set to be the basis of a more sophisticated system in the future. Next, please. Next slide, please. Thank you. Your Excellency, ladies and gentlemen, allow me to say that a few words about the opportunities and challenges in developing an ODR network in ASEAN. It is obvious that the opportunities are. These include having the access to a dispute resolution mechanism in the hands of consumers and businesses with one click. There is no more need for snail mail or often frustrating phone calls or helplines. The ODR enables bulk consumer claims to be processed with some degree of automation and standardization. It addresses low value and high volume complaints in the business world. Given the technology efficiency, the marginal cost of every additional complaint is very low and sometimes can even approach close to zero, resulting in a lower operating cost in the longer run. Thus, it is financially sustainable, and not to mention the legal certainty and consistency of outcomes. However, of course, the challenges of many things, including this, are many. The principal challenge is, of course, political willpower and the sunk cost of human resource and infrastructure. Other than the data protection and cybersecurity, other than that, we have data protection, cybersecurity, fairness by design, internet connectivity could be overcome with sufficient expertise, which is currently widely available. And the earlier stages, these disputes may be appropriate for only specific type of dispute, like I mentioned, such as food, travel, hotel claims, and retail industries. Certain specific skills and contextual information will be required in addition to check and balance in order to ensure that the ODR is functional in the long term. Next, please. The development of the ODR in ASEAN is still at a nascent stage. This is what notwithstanding that some AMS have indeed taken initiative to develop their national ODRs. The next milestone for the ACCP is to complete the ASEAN ODR guidelines, which is targeted to be complete by the end of this year. By first quarter of next year, we expect to complete our study on the needs and gaps to access dispute resolution and redress system in ASEAN. After that, AMS are ready, will proceed to establish their respective ODR, adding to those that have already started or in the process of developing theirs. These are national milestones to be driven by the respective consumer protection agencies in the AMS, with the support of dialogue partners. Once a critical number of AMS have developed their ODR, we will be able to establish an ASEAN ODR network according to the model set out in our feasibility study. Our target is to have the ASEAN network ODR network be online by 2025, as provided in our ASAPCP target, or earlier if possible. Next and last slide. If you would like to learn more information on the ACCP's current progress in ADR or in ODR in ASEAN, again, please follow us in our website at aseanconsumer.org. Uh, that is all from me. Once again, thank you very much for having me to present in today's event on behalf of my colleague. I wish everyone to stay safe and healthy. Thank you very much.
Thank you very much, Mr. Putu Prima Apriswajaya, for that very informative presentation. Now that we learned of the ADR in the digital world, let us further know how international ADR practitioners adapt to technological developments and its benefits for the ADR community, as well as the achievements of the United Nations Commission on International Trade Law, or UNCITRAL, Working Group 2 on Expedited Arbitration Procedures. For this topic, let me introduce to you our speaker from the UNCITRAL Secretariat, Mr. Jae Sung Lee. Jae Sung Lee is a legal officer at the International Trade Law Division, or ITLD, of the United Nations Office of Legal Affairs, which functions as the substantive secretariat for the United Nations Commission on International Trade Law. He currently functions as the secretary of the Working Group on Dispute Settlement, focusing on expedited arbitration, and the Working Group on Investor State Dispute Settlement Reform. He has functioned as the secretary of the working groups on secured transactions, preparing the practice guide to the model law on secured transactions, and on electronic commerce, preparing the model law on electronic transferable records. Before joining the United Nations in 2007, Jae-sung served in the Korean Ministry of Foreign Affairs. A Korean national, Jae-sung is a graduate of Seoul National University College of Law, holds a Master of Law degrees from Seoul National University Graduate School of International Studies and NYU School of Law, as well as a PhD in law from Seoul National University. Ladies and gentlemen, let us all welcome our speaker, Mr. Jae Sung Lee.
Good day to all. As introduced, my name is Jae-sung Lee, and in the next 10 minutes, I would like to highlight 10 things that you need to know about the newly adopted UNCITRAL Expedited Arbitration Rules, which are referred to as the Expedited Rules, in contrast to the UNCITRAL Arbitration Rules, which I shall refer to as the UNCITRAL Rules. First, why was the Expedited Rules prepared? The member states of UNCITRAL recognize the value of expedited arbitration and their increased usage as a streamlined and a simplified procedure for settling international commercial disputes within a short time frame. This makes it possible for the parties to reach a final resolution of the dispute in a cost-effective and a timely manner. And it was prepared bearing in mind the need to preserve due process and fair treatment. Second, who prepared it? Working Group 2 of UNCITRAL began work in February of 2019 and completed its work in March 2021. And the Commission adopted the Expedited Rules as an appendix to the UNCITRAL Rules in July 2021, this year. The Expedited Rules entered into force on 19 September, and the accompanying explanatory note was finalized in late September. I function as the Secretary of the Working Group on Dispute Settlement, which is composed of the member and observer states of UNCITRAL, as well as invited intergovernmental and non-governmental organizations, which included a number of arbitral institutions, those who have introduced expedited arbitration rules. Third, when does the expedited rules apply? To incorporate the expedited rules, a new paragraph was included in the UNCITRAL rules with the phrase, where the parties so agree. This means that the parties' express consent is required for the expedited rules to apply. A mere reference to the UNCITRAL rules would not trigger the expedited rules, and a specific reference is required. And unlike other institutional rules, there is no other threshold, for example, based in the amount of the dispute or the application of the rule. When the arbitration is conducted under the expedited rules, the 16 articles therein apply in conjunction with the articles in the UNCITRAL rules, unless those have been explicitly replaced or modified by the expedited rules. Now, even when the parties had opted for expedited rules, the circumstances may have changed so that the expedited rules are no longer appropriate for the dispute. In such exceptional circumstances, there is a mechanism for the parties to withdraw from expedited procedure, and the determination of which is left to the arbitral tribunal. Fourth, what kind of disputes should be referred to expedited arbitration? While the parties cannot predict whether and how the dispute would arise, they should take into account, among others, the urgency to resolve the dispute, the complexity of the transactions and the number of parties involved, the anticipated complexity and the amount of the dispute, and the amount that they wish to spend on such proceedings. Agreeing to expedited rules does not mean that only the arbitral tribunal is bound by the stricter timelines. Parties themselves also have the obligations to act expeditiously and to cooperate in ensuring the efficiency of the proceedings and the swift resolution of the dispute. This is particularly so as the expedited rules, like the UNCITRAL rules, have been prepared in an ad hoc context, with no administering institution in mind to manage and further expedite the process. Fifth, how expedited is expedited? As in any arbitration, tribunals in expedited arbitrations have the duty to conduct the proceedings, avoiding unnecessary delays and expense. but the key characteristic of the expedited rules is that there's a shorter time frame for rendering the award. The last article of the expedited rules, Article 16, was one of the mostly debated rule during the deliberations. It provides a 6-month time frame for rendering the final award, that is, 6 months from the constitution of the tribunal. There is also an extension mechanism in case there is a need for more time, but also safeguards to ensure that the extensions does not become systematic. For example, extensions are allowed only in exceptional circumstances, and the maximum overall time frame should not be more than 9 months. 6. What does this mean for the parties? The expedited rules introduce shorter time frames that apply to the parties as well. The claimant is required to submit its statement of claim together with the notice of arbitration, and in addition is required to propose an appointing authority, unless the parties have agreed on one, and the appointment of the arbitrator. This is to facilitate the speedy constitution of the arbitral tribunal, which often takes up most of the time during the proceedings. Upon receiving the notice of arbitrations and the statement of claim from the claimant, the respondent is allowed a 2-stage reply. He or she has 15 days to submit the response to the notice. For the longer period, for the statement of defense, 15 days from the constitution of the tribunal. 7th, how is flexibility preserved? The expedited rules emphasize the importance of consultations between the arbitral tribunal and the parties. A case management conference should be held promptly after and within 15 days of the tribunal's constitution to ensure an efficient and fair organization of the proceedings. The expedited rules further emphasize the discretion of the tribunal in a number of instances. For example, Article 10 clarifies and reinforces the discretionary power of the tribunal with regard to timeframes. Article 11, to not hold hearings in the absence of a request by a party. This means that the proceedings can be conducted on the basis of documents and other material. Article 14 emphasizes the discretionary power of the tribunal to limit further written statements. For example, the tribunal may decide that the statement of claim and the statement of defense is sufficient. And Article 15 clarifies the discretionary power with regard to documents or other evidence, if any, are to be produced by the parties. 8th, are technological developments like remote hearings reflected? Of course, this is also done by emphasizing and expressly providing for the discretions provided to the tribunal to make the use of a wide range of technological means to conduct the proceedings, including when communicating with the parties. This allows for consultations and hearings to be held without the physical presence of the parties or participants and in different locations. Yet the arbitral tribunal should be mindful that the use of technology is subject to due process requirements. And in that light, the tribunal should give the parties an opportunity to express their views on the use of such technology and consider the overall circumstances of the case, including whether such technological means are at the disposal of the parties. 9th, some procedural elements of the expedited rules. As one might guess, the default rule in the expedited rules is a single arbitrator, a sole arbitrator. Parties, however, can agree on more than one arbitrator in light of the particulars of the dispute and if they feel that the collective decision-making is preferred. Parties are encouraged to reach an agreement on the appointment of the sole arbitrator, which may not be always easy. Therefore, the expedited rules contemplate an early engagement by the appointing authority, as a party can reach out to the appointing authority 15 days and not 30 days as provided in the institutional rules after its proposal had been received by all other parties. While it is important that the parties agree on the choice of an appointing authority, when the parties have not agreed on one, the expedited rules provide a mechanism for the Secretary General of the PCA, the Permanent Court of Arbitration, to designate an appointing authority or to serve as one, which is a departure from the institutional rules. By simplifying the 2-stage process of the designations and the appointment in the institutional rules, this should result in the time saved. Last, expedited arbitrations for investment disputes. One issue that came up during the deliberations was the use of the expedited rules to resolve investment disputes or those involving states. This is because the UNCITRAL rules are often used in such disputes. And the working group considered that whether the expedited rules was suitable for investment arbitration is a question left to the disputing parties, as in any case, the express consent of the parties is required for the expedited rules to apply. If they so wish, states could refer to and consent to the expedited rules in their respective investment treaty by making a reference to the expedited rules, based on which an investor claimant may consent to use the expedited rules. So with that, I hope I was able to guide you through the expedited rules in an expeditious fashion. One should be mindful that the objective of arbitration should not be only for a quick resolution, but a fair one. With this in mind, please help us in promoting the new UNCITRAL expedited arbitration rules so that they become known to the businesses, the middle-sized and the small-sized businesses who need it most. Further information about the rules, including the explanatory note, is available on the UNCITRAL website. I thank you for your attention.
Thank you very much, Mr. Jason Lee, for that informative presentation. We know that you've got a lot of information from today's session. With that, allow us to give you a short break, as well as an energizer to keep us up for today's convention. For this, we bring you the UST Salingawi Dance Troupe, featuring their performance of a folk dance, the Jota Moncadena. Jota Moncadena is a folk dance from the Maria Clara Suite, adopting Spanish and Ilocano dances. Originating from the Luzon Islands, this jota is performed with a partner using bamboo castanets. The Salingawi alumni won third place in the NCCA Sayaw Pinoy 2018 Folk Dance category with Jota Moncadena as their piece. Ladies and gentlemen, presenting the UST Salingawi Dance Troupe. Thank you very much, UST Salingawi Dance Troupe, for that winning performance. For our audience whose interest was captivated by the folk dance, we made sure you'll get to watch more of such performance in the next 2 days of our convention. We now proceed to the reaction and panel discussion. To moderate this session, we have attorney Julius Anthony R. Umila, an OADR accredited arbitrator and the senior vice president for development of the Philippine Institute of Arbitrators Incorporated, or PIARB. Ladies and gentlemen, we now turn the floor over to attorney Umila for the panel discussion.
Good morning, good afternoon, good evening, everyone. Thank you for joining us in this event. Let me introduce to you our reactors. We have three distinguished arbitration practitioners who will give their respective reactions to the talks given by our speakers a while ago. I'll introduce to you each of them before we ask them to give their respective reactions. First is we have Attorney Jesucito Morales, who is the president of the Philippine Institute of Arbitrators. He is currently the chairman of the Regional Arbitral Institutes Forum and the immediate past president of the Philippine Institute of Construction Arbitrators and Mediators. He's also the immediate past dispute resolution administrator of the wholesale electricity spot market. He is an accredited arbitrator of the PDRCI, Construction Industry Arbitration Commission, and the Philippine International Center for Conflict Resolution. He is a recognized arbitration expert, not only locally, domestically, but also here in our region, Asian region. Our next reactor is Attorney Ian Ray Malilong, who is a member of the Chartered Institute of Arbitrators and an accredited arbitrator of the Integrated Bar of the Philippines and the wholesale electricity spot market. He is also a trained arbitrator of the Philippine Dispute Resolution Center. He is a trustee and officer, respectively, of the Philippine Institute of Arbitrators and the Philippine Bar Association. He is likewise the current director for arbitration and alternative dispute resolution of the Integrated Bar of the Philippines. He is a graduate and alumnus of the University of the Philippines College of Law. Mr. Malilong is a partner at the Solis Medina Fajardo and Malilong Law Offices. Our third reactor is Attorney Daniel Hofilenia, who was a senior consultant for the Intellectual Property Office of the Philippines, IP Academy, and a founding partner at Calao, Prasad, and Hofilenia Law Offices. He is a professor of law, teaching international law at the Central Escolar University School of Law. He finished his Master's of Laws in International Dispute Settlement at the Center for International Dispute Settlement of the Graduate Institute and the University of Geneva Law School, and his Master's in Applied Economics at the De La Salle University here in Manila. Good afternoon, gentlemen. Our audience is very much excited to hear your reactions to the presentations of our speakers a while ago. So let's start with our president of the Philippine Institute of Arbitrators, Attorney Jesucito Morales. Your floor, Mr. Morales.
Thank you, Attorney Omila. Good morning, everyone. Many thanks to our distinguished speakers on these most relevant topics of the hour, that is ADR in the digital world, how technology redefined ADR in the world, and ADR shift to digitalization, understanding how international ADR practitioners adapt to technological developments and its benefits for the ADR community. Indeed, innovations brought about by information technology have altered the way consumers, industries, or businesses operate. And ADR, or the way we resolve disputes arising therefrom, is no exception. People have a name for this development, or shall I say, phenomenon. They call it disruptive technology. Disruptive because it sweeps away the systems or habits it replaces, as it has attributes that are recognizably superior. Undeniably, employing IT in ADR is compelling, even as our esteemed speakers have made that central in their presentations. In thus, we can truly place ADR in the digital world. But how far into the digital world? So far, we have seen in ADR exercises contemplated in the presentations the merger or synergy of the physical world and the virtual world. That is to say, ADRs taking advantage of the wonders of information technology to make ADR readily accessible to many, as it is convenient and very cost efficient. That is made possible by the elimination of the obvious barriers to accessing justice, and with it, expedited procedures for all its good causes can, as discussed by Mr. Jason Lee, practically be assured. In the meantime, online consumerism has engulfed the world, accelerated by the COVID-19 pandemic, to the extent that the locations of the online buyer and the online seller are quite distant or remote from each other. ADR of disputes between them is, as our speakers have indicated, also done online with legitimacy and wide acceptance, enforceable even, particularly for, as mentioned by Professor Yoshihisa Hayakawa, low value e-commerce transactions. The processes of some of these online dispute resolution or ODR are algorithmically administered by artificial intelligence. Well, legitimacy or enforceability of resolving disputes by artificial intelligence is so far not being questioned for online consumerism transactions. But how about resolution of disputes that have arisen not online but from offline or traditional transactions, especially those complex ones? Is the ADR community also moving towards that direction? And if so, are we ready for that ADR big shift to digitalization? We have seen how successful the hybrid platform has been. That is a merger or synergy of the physical world and virtual world. But as our speakers have indicated, some sectors have been advocating for a fully digitalized ADR for disputes arising from the offline or traditional transactions, and not merely limited to the online consumerism transactions. Or as Mr. Putu Apriprima Swajaya says, the ASEAN is slowly moving towards a fully automated systems. But is the ADR community ready for that? That is to submit to a rule of law application, particularly one that is non-territorial, rules of procedures, party representations, or as he mentioned, robot lawyers or chatbots, and selection of neutrals as algorithmically administered by artificial intelligence, or as Mr. Prima Swajaya calls it, predictive justice. Its cost is most certainly very low compared to the conventional ADR platform, and the processes significantly time efficient, consistent, and perhaps intelligent. But how about the things that the ADR community values most, like confidentiality, the human emotions that occasionally attend ADR modes like mediation, and the sense of justice or fairness as humans know it? Can artificial intelligence evolve efficiently and effectively enough to overcome these barriers? Well, these Internet of Things questions are compelling, and we can only thank our distinguished speakers, namely Professor Yoshihisa Hayakawa, Mr. Putu Apri Prima Swadjaya, and Mr. Jae Song Lee, for having kindly shared with us their invaluable insights on this rapidly emerging disruptive technology as applied in ADR, and to OADR for having organized this convention. We cannot thank you enough for preparing us to engage in these emerging and perhaps inevitable trends. Thank you and good morning.
Thank you, Attorney Susito Morales. Now we will now give the floor to Attorney Ian Malino for your reaction to the speaker's presentation.
Thank you very much, Julius. Good morning, everyone. I thank the organizers of the OADR for inviting me to speak in this very important event. I wish to share some inputs on Mr. Jae Sung Lee's presentation on the new UNCITRAL expedited arbitration rules. My brief reaction will focus on the rules Article 3, Paragraph 3, regarding the utilization of any technological means appropriate for the arbitration proceedings, which to me is apt for the theme of this conference, ADR and technology. First, on the application of the said provision, please take note that it is merely permissive. The tribunal cannot unilaterally impose on the parties the use of any technological means in the conduct of the arbitral proceedings. In exploring this option, the tribunal must invite the parties to express their views on the matter. This is consistent with the principle of party autonomy, which gives the parties freedom to make their own arrangements to resolve their dispute. Furthermore, emphasis must be made on the phrase taking into account the circumstances of the case. This covers a situation where a chosen technology may not be available to one of the parties. For example, a South Korean claimant alleging that it needs to see the body language of the party's witnesses proposes to a Filipino respondent to have a hologram conferencing during oral evidentiary hearings, a la Coldplay BTS My Universe music video. While this may be easy in South Korea, owing to its prevalent 5G technology, its Filipino counterpart may be ill-equipped and has no such facility. The arbitral tribunal may therefore have to decline the request in accordance with the principle of equal treatment of the parties and full opportunity to present their case. Which leads me to my second and last point. What then are the advantages of the use of technology in ADR? For one, technology has democratized or leveled the playing field in arbitration or ADR in general. For instance, the advent of internet has resulted in the proliferation of online sources. These greatly help solo ADR practitioners to have access to a wealth of ADR resources which hitherto were only available to established law firms. Translation of documents has likewise become generally hassle-free. Just use Google Translate or a similar app. Another benefit is that technology has, again, generally helped reduce the cost of arbitration. The accessibility of video conferencing apps such as Zoom, Google Meet, and Microsoft Teams in hearings has resulted in significant savings in transportation and hotel expenses for the parties. This becomes all the more obvious when arbitration is international in character. The promotion, therefore, of the use of technology in arbitration under the new UNCITRAL expedited arbitration rules is warranted. It is consistent with UNCITRAL's as well as OADR's noble objective, equal and easy access to justice. As I close this brief discussion, I join the caution of Ben Giarreta in his lecture entitled, "What Will Arbitration Look Like in a Future World?" before the Faculty of Advocates Arbitration in a 2019 Scotland conference. He says, "We must not be overly dependent on technology, that we might lose sight of the essential nature of arbitration and of what areas can be improved and what areas should be left alone. Arbitration will continue to be a human endeavor, an art and not a science." Thank you very much, everyone, and good day to all.
Thank you, Attorney Ian. Ladies and gentlemen, we'll now hear from Attorney Daniel Hofilenia. Attorney Daniel.
Thank you, Attorney Julius, for that introduction. So, even with advances in technology and the adoption of different rules like expedited procedure and emergency arbitration, the overarching theme of Mr. Lee is that we should always go back to the basics. As our esteemed resource persons have highlighted, we always need to observe the core principles of arbitration: due process, equality of parties, and party autonomy. In his first point, Mr. Lee stressed the importance of due process and the fair treatment of the parties. As arbitrators, this should be our guidepost on how we will conduct our arbitration proceedings. Sometimes, there is a temptation to fast track proceedings in order to save time and costs, particularly when parties expressly agreed to expedited proceedings. Nonetheless, we should always bear in mind that it is important to give the parties an opportunity to be heard and to comment. We should never sacrifice due process for the sake of a speedy resolution of a dispute. Another point that Mr. Lee highlighted is the applicability of the rules only when the parties so agree and only by express and specific reference to the rules. This principle is an acknowledgement of the consensual nature of arbitration and party autonomy. Naturally, the expedited procedure provides for an abridged version of the arbitration proceedings. Well, I need not delve into this concept as Attorney Malilong has extensively discussed this. Given all of these core principles, it was stressed that even though the arbitral tribunal has flexibility in the conduct of the arbitration process under Article 9 and Article 10 of the expedited rules, the arbitrators must always bear in mind that ultimately due process must be respected. Another point that I would like to talk about is the rapid development in technology. As previously discussed, Article 3 of the rules allow the tribunal to utilize any technological means that it deems appropriate. Still, in doing so, we should always bear in mind that access to technology may vary between the parties. Such, again, we cannot sacrifice due process for the sake of convenience. One final point that I would like to highlight is that all our esteemed speakers, Professor Hayakawa, Professor Swajaya, and Mr. Lee, are in agreement that technology is changing arbitration. Because of technology, arbitration is becoming accessible. Parties, their counsels, and arbitrators can now meet at any time, even though they are located in various jurisdictions. Arbitrators can now schedule back-to-back hearings for different cases as the need to travel has been eliminated. In sum, due to this radical shift in the way we conduct arbitration proceedings, I see that the use of arbitration will break barriers in the next few years, and that the arbitration rules, processes, and even the software supporting arbitration, like Zoom, Teams, will continue to evolve to accommodate purely virtual hearings. Even though the use of artificial intelligence to resolve disputes is slowly becoming popular, as Mr. Swajai has pointed out, we as practitioners should embrace it because this digital revolution will also give birth to new careers in ADR that we can get into. So thank you to our esteemed panel, Professor Hayakawa, Professor Swajaya, and Mr. Lee. I would also like to congratulate the OADR for this successful initiative and for the invitation. A good afternoon to all and stay safe.
Thank you, gentlemen, for your wonderful insights. We'll now move to our panel discussion. Yeah, I'd like to ask this first question. Yeah, any of our panelists or reactors can answer this question. Mr. Jason Lee earlier on discussed about this expedited procedure for possible adoption in an ad hoc arbitration. Yes, based on experience, when an arbitration is commenced, generally claimant will always have the advantage in the sense that claimant will have the good amount of time to prepare its theory, all its documentary and testimonial evidence, so on and so forth, compared to the respondent. Now, given this prospect of disputants possibly adopting the expedited procedure, we have these now UNCITRAL rules on expedited procedure being offered for possible adoption in ad hoc arbitration. How do you think will this procedure will be received by our practitioners and commercial disputants here in our jurisdiction, given that reality, wherein in an arbitration generally a claimant will always have the initial advantage, and given that the proceedings is expedited, how do you think will that expedited procedure be received here in our jurisdiction? Who wants to offer an answer? Our distinguished president of the Philippine Institute of Arbitrators.
Yeah, right. Thank you, Attorney Julius. First, we must go back to the value, the advent of ADR is that it has broken the barriers to securing justice, which are time and cost. Therefore, uh, the expedited procedure is advantageous, of course, because again, it enhances the value that has broken the cost and time barrier. Um, the question in the end is basically the legitimacy and the enforceability, which, as mentioned earlier by Mr. Lee, is that since it is part of the rules to which the parties would have submitted to, but then as mentioned, as in highlighted by Attorney Malilong earlier, is the that it may not be forced upon the parties. So the expedited procedure might be used in the administration of ADR, provided that parties have been given opportunity. Because at the end of the day, the question is the legitimacy. The acceptance is there, yes, but the legitimacy and the enforceability. But then it is advantage again because it has broken the traditional barriers via litigation in securing justice.
Yeah. Another follow-up question, Attorney Morales. Based on your extensive experience as one of our recognized experts here in our jurisdiction, we also have a similar set of expedited rules incorporated in the arbitration rules of our domestic arbitral centers here. Based on your experience on the cases that you have handled so far, either as an advocate or as an arbitrator, have you encountered a good number of cases which have adopted this expedited or similar expedited procedures?
Yes, but not quite in the Philippines. You will note that um, at the end of the day, the test is the enforceability of like an emergency award or an expedited procedure award. You will note that our ADR Act of 2004 adopted the UNCITRAL model law of 19 the older one, but not the 2006 amendments, wherein the 2006 amendments included the this expedited or the emergency procedures, so that at the end of the day, since the 2006 amendments have not been incorporated yet into our legal system, the it's basically whether or not the courts would have enforced such um, issuances pursuant to this expedited or emergency. And we are hoping, of course, that we will amend our law to adopt the 2006 amendments. But then to answer the question, I have seen yes, but more of outside the Philippines than within the country.
Thank you, Attorney Morales. Attorney Daniel just sent me a private message. He wants to add to your statement, answering my first question about this reality in arbitration, wherein the claimant normally has the initial advantage when it commences arbitration. Attorney Daniel?
Thank you, Attorney Julius. So, as President Morales has pointed out, the parties do agree that the expedited procedures will apply. But I would also like to highlight Article 2 of the same procedures. Article 2 of the expedited procedures also says that the parties can also agree to opt out of the arbitration, the expedited rules, even during the course of the arbitration proceedings. Moreover, the arbitral tribunal may, upon its discretion, determine that the rules should not apply anymore. In these cases, the tribunal can consider whether the dispute can be adequately resolved using the expedited rules. And of course, as what President Sito has said, it should not affect the enforceability and the integrity of the award. So that's it. Thank you, Attorney Julius.
Thank you, Attorney Daniel. Attorney Ian, you'd like to add to those inputs?
Yeah, I would just like to make a brief note on the acceptability of the expedited rules, particularly on ad hoc arbitration, from the perspective of the user or the client. More often than not, the dispute arose from a business relationship. So from the user's point of view, from the client's point of view, they usually want to put an end to their dispute as soon as possible. So they just want to move on. So I think from the perspective of the user, the business owners, it is a welcome development because it provides them a very fast, efficient, and expeditious way of resolving their dispute.
Yeah, thank you so much, Attorney Ian. Now, let me now move to my next question. From a practical and, well, strategic standpoint, in relation to this possible adoption of expedited procedure in arbitration, when do you think should a party agree to adopt expedited procedure? Should it be in an arbitration agreement outright or during the discussion on the terms of reference? Can you give us your insights based on your experience? Attorney Morales?
Yes, thank you, Attorney Julius. I would say that during the formulation of the terms of reference, because it was only then when the issues and claims would have taken shape, and therefore the parties would be guided as to whether um, the type of disputes that they have is susceptible to this expedited procedure, so that the opportunity to be fully heard is not sacrificed.
Yes, thank you. Do you agree with that statement, Attorney Ian?
Yeah, I agree with the statement of Attorney Morales. Although there are some parties or litigants also that after the dispute has arisen, it will be very difficult for them to agree on something. So there are instances wherein delays are caused because of uncooperative parties. But I agree with Attorney Morales' statement that it should be during the drafting of the terms of reference where the issues have been identified and laid out.
Thank you. Yeah. Before we move to Attorney Daniel, Attorney Ian, I have a question for you. You mentioned about body language in virtual arbitration hearing. Uh, can you share your insights with our audience? What is the significance of body language in arbitration, and why is that quote unquote sacrificed when we conduct virtual hearing?
Okay. Body language is basically non-verbal communication, right? You communicate your behavior non-verbally or information through your acts. It is important in hearings, well, for some judges and arbitrators. They want to see the person uh, when he reacts to a specific question. So, for example, a judge or an arbitrator might sense that the witness is lying because he keeps on fidgeting. He's uncomfortable with his answers, or he does not look the arbitrators or the judge directly in the eye. The disadvantage of having a virtual hearing, you only see the face, right? But not the entire body, because more often than not, the participants are just sitting, and they do not show their entire body, how their hands move when they react to questions. Which reminds me of that anecdote wherein one of the presidents of the U.S. was involved in a scandal when he was advised to speak directly in front of the nation. He was advised to uh, look straight to the camera so that people will believe him. So that's the importance of, I think, of body language.
Uh, will the members of the panel want to add also to the observation of Attorney Ian?
Yeah, thank you, Attorney Julius. So to some extent, the technology has overcome that barrier. In fact, as we would have seen the contemplation of the ICC guideline, which says in person by virtual means. In other words, on video conferencing, somehow there is some degree that the body language could be read. What would probably worry the ADR community is the ADR that is fully digitalized, wherein the one that is judging the testimony of a witness is a robot or artificial intelligence, which we understand from the presentation earlier by, I think, Mr. Swajaya. The ASEAN is slowly moving towards a full digitalization of ADR. So if Attorney Malilong worries about that, all the more probably the ADR community might have to rethink if ever the artificial intelligence or the IT, yeah, artificial intelligence technology would ever overcome that barrier.
Uh,
Attorney Daniel, you want to share
Attorney
your
Julius,
thoughts?
thank you. I'd also like to comment on the importance of body language, and I fully agree with Attorney Ian that one major disadvantage in using video conferencing during hearings that you cannot see the full body of the people that you're talking to, right? But then we could also, well, I'm a strong believer of the proverb saying that the eyes are the window to the soul. So the good thing about online hearings is if that person is reading off a script or is actually spontaneously speaking before you. And at the same time, uh, one good thing about these virtual hearings is that these hearings are recorded, and you could always review the body language of everyone speaking before you at any point in time, and even multiple times. But that's just one advantage that I would like to highlight. But then again, I do fully agree with what Attorney Ian and what President Sito has said, especially when it comes to the presentation of testimonial evidence, and that may pose difficulties not just for the counsels but also for the arbitrators in assessing the credibility of the witness.
Yeah. Well, the reason I asked that question is, yeah, there's another school of thought saying that it doesn't really matter whether the witness smiles or blinks when he answers, because what really matters is what's put on record, especially the documents supportive of a party's position. Well, candidly, I happen to belong to that school of thought. Anyway, let me move to my next question, gentlemen. Uh, Given that we are now in the modern age, from the standpoint of the arbitrator or the arbitral center, uh, can we presume that pertinent technology is now available to a party disputant, party to an arbitration? Should that be the presumption now? Because we had a case last year, and here was this respondent who kept on raising this as an excuse that his Zoom, what you call this gadget, is in the office but not at home, so on and so forth, causing so much delay. But yeah, going back to my question, is it now going to be a presumption that now that we are now in the modern age, pertinent technology is available to parties to an arbitration? Who wants to go first? Attorney Cito?
I would say yes, but I will qualify that only to the extent that technology assists the tribunal and the parties, but not to replace as suggested by the ODR proponents. Remember, ODR is not online ADR. ODR basically replaces. Now, that the presumption might be well said because you see, these things are, as they call, a disruptive technology phenomenon. By disruptive, it disrupts because it is inevitable. The businesses, industries, and consumers can no longer ignore the compelling need to use the IT technology. That is why it is called disruptive. That is why the presumption, that is why it must be presumed that administering institutions would have this as already a compelling part of the exercise, but assistive and not replacing.
Uh, the other gentleman, would you like to add to share your inputs as well?
Yeah.
Attorney Ian, go ahead.
Yeah. I would just like to briefly point that I think the our basic need now would be the available accessibility to connectivity, right? Internet. I think it's one of the basic needs now. If we if we follow the if we follow Maslow's hierarchy of needs, maybe it's on at the bottom of the hierarchy. Having said that, it's good that we have more players now, more providers, internet providers. In fact, there's a new third player, and then the other one, a broadband provider, has launched its IPO. So there's massive building of infrastructure, making this technology available to everyone. And I think in hopefully soon in the future, the our government might again entertain the idea of having a national broadband service which provides free access, internet access to everybody. So if we have that, I don't think there would be now a valid excuse for having no access to technology when it comes to hearings, etc.
Attorney Daniel, you want to say
I
something?
think yes, thank you, Attorney Julius. So I think the presumption is correct that all legal counsels should have access to internet, and at the same time, their devices must be ready, especially during an online hearing, because our job as counsels is to always prepare beforehand. So I think it wouldn't be an excuse for a counsel to say that they don't have internet connectivity, especially if they were given notice or prior notice to the hearing. Nonetheless, I think as arbitrators, we should exercise extreme caution when working that assumption against a party, because at its core, arbitration should always give the parties the right to be heard and the opportunity to be comment. So that's it on my part.
Yeah. The reason why I asked that question is because yeah, I we used to see these various models or versions of protocols on video conferencing in arbitration. And personally, since I'm not really a high tech guy, once I reach that stage where we see specifications on technological requirements, I really get overwhelmed. No? Yeah, that's a challenge for me as a practitioner in this area. Now let me move to my next and hopefully my last question. Attorney Ian quoted a known expert, Mr. Ben Chiaretta. Is that the way you pronounce his name? He's known expert in the field of international arbitration. I think he's a fellow of the Chartered Institute of Arbitrators, where most of us here also belong. Um, he cautions our overdependence on technology while losing sight of the essential aspects of arbitration. What do you exactly mean by that, Attorney Ian, when you gave that quotation?
Yeah, I think it's best illustrated or explained by the presentation of Attorney Morales earlier, when he said that um, we should be wary of having our disputes resolved by an AI, because if we are overly dependent on technology already, to the extent that we substitute AI technology with we substitute our arbitrators with human arbitrators with AI or robotic arbitrators, then that's where the problem would really arise. Because as Mr. Gareta emphasized, uh, the arbitration problems are human. These are these have to be resolved by humans also, not by robots or AI apps.
Attorney Sito, you want to add to the statement of Attorney Ian?
Yeah, two things. First, there is a huge paradigmatic change. Some authors would say that this lie in four areas: physical, psychological, conceptual, and the professional. Professional because the lawyers will no longer be needed in the fully digitalized ADR. Now, um, scientifically, of course, I have to say that because I am an engineer also. Humans think deductively, so that therefore they structure laws to be followed in the, for instance, in a dispute resolution. But I, I read that computers or artificial intelligence think inductively. In other words, since they are not attached to any territory whose governments basically make laws, they structure their rule of law application from the social network behavior. That is why, based on those behavior, they inductively uh, come up with the rule of law. So I don't know if we would worry, but I think we might, because as mentioned by the scholar quoted by Attorney Malilong earlier, is that we don't know the future. Can artificial intelligence really efficiently and effectively replace humans? Especially as what mentioned by Mr. Swajaya earlier, the predictive justice, um, wherein these things are algorithmically administered. We are told that artificial intelligence are consistent and might be intelligent. What we are concerned about is that would this be enough to replace justice as humans know it?
Thank you, Attorney Sid. Attorney Daniel, you want to share your thoughts?
Thank you, Attorney Julius. For me, every dispute has a human component. Dispute arises not just because of conflicting legal rights, but also because the parties have different interests. And I think that is one thing that machines or artificial intelligence cannot outperform a real life human arbitrator. Uh, a machine cannot see the humanity in a dispute. And I think that's it. And that artificial intelligence, if it's going to be used, should only be utilized for simple disputes and not those disputes which are very complex or disputes which are very human. Thank you.
Thank you very much, gentlemen, for sharing your wonderful, informative insights. Yeah, I'm sure our audience this morning have learned a lot from you, as well as from our speakers as well. So I think our time is up. We have to end now, and would like to thank the organizers for giving us this opportunity to let you share your insights on this particular subject matter. So with that, we'd like to end our panel discussion. Thank you so much.
Thank you very much to our moderator, reactors, and panelists for the informative and engaging discussions. We hope our participants learned a lot from today's session of the National ADR Convention. We have reached the end of day one of our convention. For the closing remarks, we call on the OIC Director of the Policy, Compliance, and Monitoring Service of the OADR. Ladies and gentlemen, let us all welcome Mr. Ryan C. Thomas.
National partners, to our local and international partners in the ADR community, ladies and gentlemen, good afternoon to all. It has been exciting to witness the rapid growth of technology and its ever-evolving complexity. Correspondingly, it has been equally interesting to see a natural choice of technology-enabled alternative dispute resolution over litigation and adjudicative systems. Technology indeed changes the traditional theory and practice of dispute resolution in a cycle that typifies these times of global digital transformation. Let me apply the key learning of today's convention into the ADR policy and directions of the Philippines. While the current Philippine laws on ADR systems and procedures are entirely based on face-to-face proceedings, there is room for the use of online technologies, as will be covered by Day 2 and Day 3 of this convention. There are opportunities to use online technologies within the current legal framework and introduce new enabling policy instruments. A key consideration for this direction is ensuring the quality of online dispute resolution services, referring to the technology platforms and ADR neutrals. Apart from well-defined and established ADR systems in the public sector, what we have in the Philippines is the quality assurance framework for organizations and practitioners providing ADR services as neutrals, professional trainers, and expert consultants. The said framework includes standards for ADR programs and competency development, as well as a system for government accreditation and compliance monitoring. Accreditation is the OADR's mechanism to evaluate and certify the competency and quality of services of ADR organizations and practitioners that is in accordance with established minimum standards. Such accreditation certifies the fitness to provide ADR services for the government, while it is optional for services to the private sector. Meanwhile, compliance monitoring is the OADR's mechanism to ensure that the quality and continual improvement of ADR services by accredited organizations are delivered in a sustained manner. This is done through compliance and quality checks, whether business operations meet their regulatory and process obligations. As will be discussed in Day 3 of the Convention, the OADR ramped up since last year the accreditation of providers to address the supply side of ADR services, while the OADR aggressively promotes ADR at the demand side. Corollary to this, the OADR established and implemented compliance and monitoring protocols to ensure that the committed level and quality of service is continually delivered and improved. The challenge now is to calibrate these ADR quality assurance tools with the advent of domestic and cross-border online dispute resolution systems. This includes the adherence to local and international standards of both the technology platform and ADR neutrals working within the system. At the end of the day, the objective is to ensure that all online ADR providers are able to facilitate the resolution of disputes in a professional, cost-efficient, expeditious, accessible, secure, and ethical manner. Apart from this is the need for OADR to adapt by instituting technology-enabled quality assurance mechanisms. These directions and challenges, among others, guide the OADR in its promotion and development strategy as the office transitions next year to be an autonomous attached agency of the Department of Justice. The office will formulate and issue operational guidelines for its current program and accreditation standards, including compliance monitoring. More specifically, these guidelines will contain an enhanced frontline service procedure for accreditation and approval of training programs that is in accordance with the Ease of Doing Business and Efficient Government Service Delivery Act, along with compliance monitoring, including complaints against ADR organizations filed before the OADR. The enabling policy infrastructure for online dispute resolution will also be embedded in the legislative and administrative initiatives of the OADR that are in the pipeline for 2021. Finally, it is my pleasure to express that the OADR has indeed come a long way since the passage of the ADR Act. I have personally witnessed its early years when I entered the Department of Justice until my eventual transfer to the OADR. This journey towards institutional maturity has been the result of hard work by the men and women of the DOJ who started the work and the ensuing management and personnel that assumed in 2020. I end my closing remarks with the words from a famous American businessman, Barry Diller. The only way anyone is going to succeed is to build the product. Yes, the DOJ Office for Alternative Dispute Resolution builds its services with the people and its stakeholders in mind. We deliver services to you after careful study and research. We will continue such zeal and eagerness beyond 2021 and the years to come. Thank you and good afternoon to everyone. See you in tomorrow's session.
Thank you, OIC Director Ryan. Thank you very much to all our distinguished guests and dear participants for joining us. This has been day one of the NADRC 2021. Join us again tomorrow at 9 in the morning for the second day of the convention. Please follow our official Facebook page, Office for Alternative Dispute Resolution, for more updates and information about the NADRC. See you again tomorrow. Good day and stay safe.